With us this beautiful Sunday afternoon. We'll be tracking two court matters that have been running quietly behind the scene as the nation is fixed on the explosive revelations that are coming out of the Madlanga Commission. But first, Senzo Meyiwa murder trial has reached a critical stage. The alleged gunman, that's Vusimuzi, he's taken the stand to testify in his defense, doing so in the presence of Vusimuzi Meyiwa, that's the mother of Senzo Meyiwa, who for the very first time this past week came face to face with the alleged murderers of her son. So that was quite interesting to watch, but also we'll be focusing on the Katmatla case, a trial within a trial unfolding in that particular matter in relation to the arrest and of course certain recoveries that were made when one of the alleged hitmen, Musa Kekana, was arrested. All right, so our poll question is back and we want to know what your thoughts are on the first week of the alleged gunman's testimony on the stand. We've got a number of options on the screen. The first one being on the right track. The second one, unclear testimony. So if you feel like he's given unclear testimony, that's the one for you. The third one saying you are happy with the defense strategy at this point. But the last one also saying no direction. So make sure to scan the QR code and start voting using, of course, that QR code that is on your screen. You can also send us WhatsApp messages and voice notes as well as videos. The number is 072-110-5584. Those are the numbers that you need to send all your comments to in fact participate in this particular conversation. Also a reminder that the poll question on your screen does not necessarily reflect the position of the court or of the case, but rather a conversation amongst the people that are watching the trial that is unfolding at the Pretoria High Court. So make sure that you engage with it, and we'll of course make sure that we read those messages throughout the program. All right, we start here. Week one of the highly anticipated high-stakes testimony of the alleged gunman, Vusimuzi, finally kicking off this past week. Now, it's the state's case that Vusimuzi was the short, dreadlocked, gun-wielding intruder who entered the Kumalo home along with one of these co-accused, that's Bongani Ndanzi, demanding cell phones and money before the footballer Senzo Meyiwa was killed. Among the first things that Vusimuzi dealt with was the description of the incident by some of the people who were in the house at the time of the shooting. Take a look.
Do you have anything to say with how, not who, but how she described how the incident happened?
I don't have anything to say, my lord, since I don't know what happened.
When you say you don't know what happened, what do you mean, Mr. Mnisi?
Ushubthini mathi uyawazi ukuthi ke kwenzakaleni?
Angisho akazi ukuthi into enzeke endlini yonke angazi ukuthi kwenzakalani.
What I'm saying is that everything that transpired inside the house, I have no knowledge of.
Angekho futhi esangiye lapho.
I was not present and I did not go to that place.
Now, Vusimuzi also giving testimony in relation to the description of the alleged intruders.
He was average height with dreadlocks.
Omunye ke ubephethe oqala ke ubephethe ke isibhamu esandleni futhi ke ubelingene nje phela futhi nama dreadlocks.
Dark in complexion.
Emnyama.
Thin in body.
Enomzimba futhi omncane.
Wearing a brown jacket or beige in color.
Egqoke ke ijacket ke ebrown noma ke ngathi uba beige. Umbala wayo.
And he was wearing a small tops on his head.
Ubegqoke ke tops encane ke ekhanda lakhe.
He had big eyes.
Enamehlo amakhulu nje.
But I can be able to identify him if I see him again. The second suspect was behind the first one.
Owesibili ke ubesemuva kulo oqala ke umsolo.
He closed the door.
Wase ke evala umnyango.
He was a little bit taller
Ubengaba mude nje.
than the other one.
Ube mude kulo omunye.
He was a little bit light in complexion,
Ubekhanya nje kancane.
and I can also be able to identify him if I see him again. Do you have any comments?
Khona mhlawumbe ufuna ukusho kulo kakusho.
ukuba kuthiwa kuyimi lo wayengeke akhulume ngomuntu omnyama.
If indeed she was describing me, my lord, she would not have mentioned somebody of dark complexion
Ngoba nje ngimhlophe isidalo nje.
because I'm light in complexion naturally.
Yes.
So manje mina ngimhlophe ndawo yabasho ngakhona abathi ungena umuntu omnyama nomhlophe endlini. Mina ngiyime ngimhlophe njengamanje la.
All right, let's bring in my panel of guests this afternoon. In studio, I have Mabelane, a very good friend of the show who gives a regular commentary on the proceedings in the courts. We also have Mnisi as well as Bongiseni Gunene joining us via video link. These are our legal analysts who will help us unpack what, of course, we'll be discussing this afternoon. So let's start here in studio. Mabelane, thank you very much for joining us and welcome back. The last time we saw each other was before the recess. But now we're back. It's week 2 of the proceedings. And I want to first start with you, with Bongani Ntanzi, I would say abruptly ending or closing rather his case.
Yeah, it felt like that moment when you are listening to music and there is load shedding. You don't necessarily know what happened. So Bongani Ntanzi has promised us that he's going to bring Capitec to dispute the statements because it's not true reflection of what these statements looks like. But it was shocking to see him closing his case without calling Capitec, without calling any of the family members to substantiate that he had a ceremony at home, which included the lobola. Those are some of the things that we expected him to do. He didn't call Levo Petani, whom he spent much of the time speaking to on a telephone. And what was interesting was when Correctional Service came, it was very interesting to realize that, in fact, Capitec has given Ntanzi his statement as early as the beginning of this year, which means when he took the stand, he had the statement for those days when Senzo Meyiwa was killed, but he still disputed it. If that statement was showing anything different to what the state presented, he should have presented it before the court. So he doesn't have alibi. We don't know where he was. He was definitely at the First Lawyers Hostel on that night, and he went to Davidton after that.
Let's talk now about the case of Vusimuzi, high-stakes testimony. It's what I've been referring to it as throughout this particular week. Quite interesting that the conversations that are coming out, as of course he continues to give testimony, is around his evidence in chief and perhaps the strategy that they've taken, not an ordinary way that we're used to, right?
Yeah, it feels like it's Mnisi who is defending his own case, but it's surprising. Maybe Mnisi knows better. The strategy has worked for him in the past, but as it stands, he didn't bring anything before court. Even today, we don't know where he was. I mean, we spent the whole of last week where he was arguing and giving his own opinion, which is not substantiated by anything. So we are waiting to hear where he was.
Let me interject there. And to be fair to him, he says, I was not there, right, when he's asked to comment about the incident and how the people that were in the house were describing how the incident happened. He said, I was not there. I wouldn't know what happened in that house because I was not there.
Yeah.
That surely is a version.
It is, but where were you? Because just to say you were not there, it doesn't take the matter any further. The court always cautions us about fanciful possibilities. You must say, I was not there, I was at this point, or at this specific place, and I'll call Linda to come and support my statement that, or my version that I was there. He doesn't tell us where he was, but what is interesting is Zungu saw him at the hostel. The people who were inside the house, they described somebody with his features and clothing. So when the state leads such evidence, you must move away, you must move yourself away from the crime to say, no, I was not there, this is where I was, so that you can rebut their version.
Let me come to my legal analysts now. Sibongiseni, I know you follow the case quite closely, and one of the things that Mabelane has already touched on in the issue of Ntanzi closing his case, but also the strategy going into Mthobisi Mncube's testimony. We know the evidence that has been led by the state. Would you say that the evidence in chief that we're witnessing is another way of presenting evidence? There's no one static way of giving evidence in chief, you know, given the fact that most of it has been about responding to what state witnesses have said and the lead investigator.
Yes, good afternoon, Linda, as well as the guest and the viewers at home. I think, well, start with Ntanzi, it's very strange anyway that he has closed his case without cementing his alibi, as he alleges that he was at home. But nonetheless, we are dealing with Mncube now, right? There's absolutely nothing much wrong about challenging the evidence of the state, but you need just to challenging it with evidence or bring evidence in rebuttal. When you are supposed to defend yourself in a criminal case, you have to bring evidence in rebuttal, not just to cross-examine witnesses in absentia. Because by the look of things, is like, well, we didn't have an opportunity to refute each and every pieces of evidence that has been tendered before court by each witnesses, Zandi, Tumelo, Gininda, you can name them. So because what is happening now, Mnisi will say, let's read this portion and what's your comment, then he will comment on that. Well, we know that at the moment when he said he was not there, automatically his defense is that of an alibi. Well, I don't see it necessary if then he does have a strong alibi just to spend more of the time refuting by just denying, other than just telling the court on the onset and say, this is where I was, and evidence is going to also to collaborate. This is that of my cell phone evidence. Amongst others, I will also call witnesses to come and confirm that during the time of the incident, this is where I was. Then you defend yourself on the onset, and this seemingly of a bad denial, just saying, I don't know this, I don't know this. That is what is happening at the moment.
Yeah. Let me come to you, Melusikulu, because some of the things that are being discussed is the issue around description, right? Because we've heard him in that particular bite. He's disputing some of the descriptions that have been given, right? And we know that there's cell phone evidence in relation to pictures of that particular day when Senzo Meyiwa was killed. He is disputing the issue around the dreadlocks and how long the dreadlocks were, saying that, well, Benkrini, so he had plaited his own, dreadlocks and the length, and all of those issues related to this particular description. Talk to us about, how important the issue of description of the alleged intruder. You and I have had a number of conversations discussing the case of State versus Mthethwa.
Yeah, good afternoon to you, Linda, to Mabelane, and to Gnene, and to the viewers at home. I think you've just touched the part that I wanted to touch about the eyesight. I know Gnene can also chip in there. When it comes to the eyesight and what happened, it's important that we describe the accused exactly as he is. If he was tall and if he was dark, if he had plaited dreadlocks or unplaited dreadlocks, that is a very key information. But it's not like the only one that is important. But once it starts having doubts, it's obviously a positive sign for Mncube. So Mncube here is saying, look, the people who described the accused who shot at the day, they are saying he was having dreadlocks, and maybe there's inconsistency. Some are saying it's plated, some are saying it's unplated. But importantly, the person is described as a dark person, and he's saying, you can see me even now. I'm light in complexion, and you've seen him for the last 5 years or so. He's light in complexion. So I think for him that is a positive sign that he's using to say the person who's described in court and on the statements is not me in terms of complexion. So that would be something that can carry him to a certain point. But like I'm saying, and I always say this, Linda, the state has to prove its case beyond reasonable doubt, but everything is looked at holistically. But I must point out that the inconsistency or the contradiction in terms of describing him in his complexion, I think it's something that is positive for him.
All right, I want us to take a quick ad break because when we come back, we'll be getting into more evidence led in the alleged gunman's case. So you don't want to miss this. Welcome back and thank you for choosing to stay with us. This is Inside the Courtroom, where we track high-profile cases in our country's busiest courts, and we're delving deep into the Senzo Meyiwa case, which is at a critical stage as the alleged gunman has taken the stand. Let's remind you now of our poll question this afternoon, and we're asking you what your thoughts are on Mncube's testimony so far. And those options are on your screen. On the right track, about 11% of you are saying that he's on the right track. 13% are saying the testimony is unclear. 23% of you also saying you're happy with the strategy, while 53% saying they see no direction in how he's given his testimony. So continue voting. Scan the QR code on your screen, and then, of course, send us your WhatsApp messages. The number to dial is 072 110 5584. Let me repeat that number for you, 072 110 5584. So make sure that you get in touch with us to, of course, continue this conversation. All right, let's continue here. One of the critical aspects relating to Mncube's evidence is the firearm. Now, you'd recall that the state led evidence that the gun found in Mncube's possession when he was arrested for a separate murder case in 2015 matched the bullet found at the Meyiwa crime scene. Now, Mncube testified about the evidence given by ballistic experts.
Of importance as it affects you, this is what Brigadier Gininda says about you. He says, I'll read from page, on page 39 on the same proceedings of the 22nd of January 2024 from line number 25. He says, the ballistic test revealed that same firearm used in the murder for which the accused was serving his sentence were used in the murder of Senzo Meyiwa.
I don't know anything about the death of Mr. Senzo. And also that the firearm killed Senzo. I don't know anything about that also. That is why I even suggested that they should involve a private expert, the ballistic expert. Because what has been mentioned, I don't believe that, and personally, I did not unalive Senzo. I don't know anything about the death of Senzo. And there is no firearm that I used or I had that killed Senzo Meyiwa.
Now, it's also the state's case that Mncube and his co-accused were executing an order by the alleged mastermind, that singer Kelly Khumalo, to murder Senzo Meyiwa. You have to recall that Kelly Khumalo was the then girlfriend of Senzo Meyiwa at the time of his shooting. Now, Mncube took aim at this allegation, questioning why Khumalo was not arrested.
And another thing, my lord, that surprises me is that the people that were in the house, they were said to be around 6, but only 3 were brought.
Mastermind.
Here in court, Gininda and Mukula gave a picture that there was somebody else whom they called the mastermind. The mention of a name was asked, or it was pressed, and then they ended up saying that person is Kelly Khumalo. They said, my lord, she had requested or asked us and my co-accused to go and unalive Senzo. But here in court, Kelly Khumalo is not here. There is a document that Brigadier Gininda said that he wrote that Kelly Khumalo should also be arrested. Because the way that document was written, if it were to reach the NPA, it was going to be an emergency arrest, that person should be arrested as in today. Gininda now said to the court that the NPA could not sign or approve the arrest.
Mina NPA yase South Africa ngiyibone ngifile kakhulu mina.
According to myself, my Lord, I feel the South African NPA has failed me drastically.
Did any witness, even him, Brigadier Kininda, came up with evidence that pointed to the motive? Why was this hit organized?
Manje mnjani Ncube ke umele uthi ke ubrigadier Kininda ke uyaqhubeka uthi ke lokhu bekuyihit ke bekufuneka ushaywe ke uSenzo. Uthi ke manje ke ukhona mhlambe ufakazi noma yena uGininda ke owazala enkantolo washo ukuthi ke bengaba yini inhloso ukuthi ke kwenzekele lesihlakani.
Ayi mina lokho angaze ngikuzwe futhi azange ngibone ufakazi washo ukuthi lokho kwenza ukuthi uKelly Khumalo azabula uKelly Khumalo azabula Senzo.
There was no witness, my Lord, that came before the court and explained or give evidence before the court that this is the reason why Kelly Khumalo killed Senzo.
Namhlanje angazi.
Even today, I have no clue or
Kodwa
idea.
kuthiwa yimi engambulala.
But it is said that it is myself that killed him.
noKelly Khumalo azange bamlethela ukuthi azochaza ukuthi umbulelelani Senzo.
And even Kelly Khumalo, my Lord, was never called before the court to come and tell the court the reason why he killed Senzo.
Ngoba kumele ngabe uyu choose number 1 la.
All right, let's bring in my guests in studio. I have Mabelane as well as Mnisi and Sibongiseni Gunene via video link. Let me start in studio. Mabelane, she was supposed to be accused number 1. The NPA failed me. How did you receive that statement, right? And how do you think the court should receive it?
Yeah, at some point I felt Rapadu should have been called to come and take that confession. It sounded like a confession. But anyway, how I felt is Ncube doesn't necessarily understand. You can forgive him. He doesn't necessarily understand the strategy. Because this is a prosecution strategy that has worked in many cases. For an example, Linda, when Shova requested Malapane to go and murder Tsogofatsopule, the state adopted the same strategy where they went for Malapane first, they got conviction, and then the second, they went to the mastermind. So it's not only in the Senzo Meyiwa case where you are seeing this strategy being implemented. He may feel he's failed by the prosecution, the NPA, but they've adopted the strategy that is proven.
Let me come to you, Sibongiseni. When it comes to the issue of that particular statement, as an accused person, she was supposed to be accused number 1 in the dock if there was to be a mastermind. And if you have conversations around this particular subject, in which, I mean, we've had countless conversations about it, why Kelly Khumalo was not arrested, the warrant situation. But Mabelane raises the question around, uses the example of the Tsogofatsopule murder case, right? And in that particular case, we know that Malapane himself had turned state witness. Here, we don't have anybody, at least at this particular point, that might turn state witness against Kelly Khumalo.
Yeah, that's correct, Linda. But however, then, whether Kelly Khumalo has been arrested now or at a later stage, it has absolutely nothing to do with his defense. Because when charges are being pressed and you need to face them individually, so, right, there is no maybe whatever collateral or whatever type of a defense that you are going to defend yourself in group or vicarious liability thereof. But nonetheless, here Ncube, whether he asked about Kelly Khumalo being arrested or not, it does not take any issue anywhere insofar as his defense, because he has to face the elements of each and every crime that has been pressed against him, being that of your premeditated murder, firearm, being in possession of an unlicensed firearm, robbery with aggravation circumstances, all those pieces of elements insofar as the case is concerned. whether Kelly Khumalo has been arrested or not at this stage, I don't think even the court can take that into cognizance and say, yes, you defended yourself. The state has failed to call somebody who sent you. There's nothing like that. The charges are pressed against him. He has to defend himself and detach himself from the said charges that has been pressed against him.
Yeah.
That is what is expected from him.
Yeah, and before I move on to Melusi Xulu, talk to us then about, the issue around the gun, because he says that is why I asked for a ballistic expert, right? You listen to him about how he responds when it comes to the ballistic expert, but when it comes to the DNA expert, he says, well, that expert is educated. He knows what he's doing. He went to school for it, and of course, he's quite, he's on point. But when it comes to the ballistics of Mangena, he seems to also want his own ballistic. How should the court then read what he's saying about this particular aspect of the firearm?
Well, it is strange. I think maybe during consultation it should have happened that Mnisi and the ex-ballistic expert, as well as accused number 3, were supposed to be in the same room. And the ballistic expert also maybe explained to him, well, this is the results and this is how he arrived to the result. But nonetheless, we know that the ballistic expert is going to come and testify. But suppose it that by now Mncube might have been having a similar knowledge, just like in the one of the DNA, that no, which is why even the ballistic expert who is going to come and testify in this court, whom I have then hired, then will go and tell this court that the said firearm, which then convicted me in the Cleveland case, tested not negative. It does not link with the crime scene from the Senzo Meyiwa case. I think that should be an assumption that should have happened when they were consulting, that Mncube knows by now what is the indeed result insofar as Dave is concerned. Yeah. That's what I was expecting.
Let me come to you, Melusi Xulu, just picking up on what Sibongiseni is saying, because we know that Dave Petersen, right, is not necessarily saying that this is not the gun. He says he did not find enough individual characteristics to conclude that this is the gun. But also you can touch in on the issue around the arrest of Kelly Khumalo and the warrant of arrest, but also the issue of the firearm. At what point do we say for certain that his expert or Mncube's expert is saying this is definitely not the gun that took Senzo Meyiwa's life?
Yeah, I would firstly like to agree with Mr. Gnene on the fact that he should have consulted with his expert so that when he gives testimony, at least he lays a groundwork or a foundation on how his experts will come and testify. And that will be easy. Of course, they will cross-examine him on that expertise, but he will obviously say that my experts will come and cover that point so that at least the version of the defense, as far as the ballistics report is concerned, or as far as the gun is concerned, he is able to lay the foundation for that. And then, of course, the experts will be there to come and assist with that, because obviously there's been a couple of things that have been picked up. The first one is that the bullet that was found, I'm subject to correction, the bullet that was found was not put in a forensic bag. It was put in a brown, I think in a brown bag or cover. So that's problem number one. Problem number two, we do a lot of cases where ballistic reports and chain of custody. When it comes to those cases, it's very important that the actual gun or whatever is being analyzed is always in the police station, and you can always account for where it was at any given point in time. So we do know that it's a fact that Mr. Mabena, that the expert, he took it to his home, and I'm subject to correction, and he said he does not trust the police. That's why it was kept at his home, away from the police station. Yeah. So the experts will be able to clarify on those things. But of course, on the things I've said, I might have missed one or two, but I'm just taking it out of my mind when I'm saying it. So I think the expert is important, and he will be able to say if it is the gun that's where killed Senzo Meyiwa, was the chain of custody correct? Was the ballistic reports correct. So I think that's what I would say about the gun at this stage. Of course, I'm not an expert on ballistic issues.
Yeah, let me quickly.
But I want to touch quickly.
Yeah.
On Kelly Khumalo, then I'll end.
Yeah.
I think we've asked that question a couple of times, wondering why is Kelly Khumalo not arrested. But I think the NPA, or rather the police, have stated that at this stage we just want to focus on this case. Once we finalize, and according to them, hopefully for them, they get a conviction, then they'll consider arresting Kelly Khumalo. Although it would have been nice for, in this case, for all the accused to be arrested at the same time and the mastermind. But I suppose there might be a few things that they want to confirm before they arrest Kelly Khumalo. But at this stage, obviously, they can only finish this case and then they can decide after. So I think for me, that is what they want to do in this case.
Yeah, and just before we take a quick ad break, Mabelani, we have literally 10 seconds, right? The issue around this firearm. There's a whole lot of issues around description of who said this was a revolver, but the state is saying the gun that killed Senzo Meyiwa was a pistol. But they're quite critical because if Mncube is able to challenge successfully this firearm as well as the description, he can say, none of these things that are supposed to place me at the crime scene place me there. You've seen also how he's heavily relied on the DNA, which he says conclusively, it says, I was not there.
Yeah, the state doesn't dispute that there may have been a revolver in that house, but what they are saying is the revolver is not the one that fired that fatal shot. So he's not going to be able to challenge that. And as far as the expect is concerned, I can tell my friends for free. We told them that Mbali is not coming to support Vusimuzi's version. We also mentioned that Capitec is not going to come to support Ntanzi's version. There is no uncle, no parents that is coming. I can tell you today, Dave is not coming to give evidence on behalf of Mncube. And this is the reason why I'm saying this. It is because he should have given, Mangena gave him his report, full report. He hasn't given Mangena his report when Mangena was cross-examined, so Mangena can challenge it. So Dave is not coming as well. They are just going to leave it like that.
Really? Oh, that's quite an interesting one, and obviously we look forward to hearing what exactly they're going to do in terms of that firearm, because of course these are quite critical aspects of this particular matter. Let's take a quick ad break. When we come back, we shift gears and get into the Vusimuzi Katmatla case. Don't go anywhere. Sibongiseni?
Yes, Nick.
Uhlekani? Udave Mathagezi. That's bold of you, hey?
I'm telling you, he's not
Very
coming.
bold. I don't know.
That's a very... Welcome back. You're still watching Inside the Courtroom, and we're, of course, looking at a number of cases. Let's shift focus now and take a look at the case against Vusimuzi Katmatla. The defense there challenging the police handling of the crime scene, where accused number one, Musa Kekana, was arrested hours after the assassination of Vereniging engineer Aman Swart in 2024. Now, police captain Pimi Sekgobela attached to the tactical response team remains under cross-examination in a trial within a trial where the defense is seeking to have key evidence declared inadmissible. Now, Kekana, an alleged hitman, is charged alongside alleged mastermind Vusimuzi Katmatla and 3 co-accused. They face a total of 25 charges, including 11 counts of attempted murder linked to 3 alleged assassination plots. Now, here's Newzroom Afrika's Veronica Mahwadi with that story.
The defense has shifted its focus from allegations of torture to the legality of the police operation that led to Musa Kekana's arrest hours after the fatal shooting of Vereniging engineer Amon Swart in April 2024. State witness Captain Pimi Sekgobela spent much of Friday under cross-examination about the sequence of events after police tracked a white Hyundai i20 allegedly used in Swart's murder to a property in Johannesburg. The state's case is that Kekana parked the Hyundai before getting into a Mercedes-Benz V-Class. Police then intercepted and arrested him before searching the vehicle. But the defense argues the Mercedes-Benz was not the vehicle allegedly used in the murder and questioned the legal basis on which officers searched it.
Now, it's also a fact that this Viano was neither spotted nor involved in the crime scene in Vereniging, or the crime that was committed in Vereniging, correct? Correct. Now let's quickly go back to the arrest. I want you to explain to me the jurisdictional requirements you relied on in order to affect, first of all, accused number 1. I want to break them down accused by accused.
It's the I-20 that was parked at number 34 is the one that was used. Is it? The one that was used in Vereniging.
Same car, the same reg, house number 34.
We were provided with the registration plate number, and the same car and the same registration was seen entering number 34.
But Baba tseneng ka yona ba ile ba tsena ka V-Class ba tswa V-Class.
The people that drove in with the I-20 then disembarked the I-20, entered into the V-Class and exited the number 34 in the V-Class.
The defense then broadened its attack to the handling of the crime scene itself.
The standing order is quite clear, am I correct, at the moment? A place is designated as a crime scene. It needs to be cordoned off immediately. A crime scene manager needs to take charge of the crime scene. And at that point, there needs to be a logbook or an attendance register kept, signing in who goes in, who comes out, and the time they go in and the time they go out, and all that was correct.
Judge Kasim Musa then stepped in, saying it was unfair to test the witness on a document that had not been put before him.
When you refer to a standing order, would you perhaps maybe be kind enough to direct his attention directly to the standing order that you are referring to, so that both yourself and the witness are not at cross purposes?
I will do so, my lord, but I first, with the greatest of respect, wish to test his knowledge of processes and his knowledge on the relevant standing orders before I show him anything.
I must say to you, counsel, this court is of the view that it's unfair because you could be referring to a specific standing order and the witness could be thinking about something else. If you are saying it authoritatively that this is what a standing order says, then I cannot see any reason as to why it cannot be presented directly to witnesses and said, here's the standing order I'm showing you now.
The matter returns to court on Monday, where Sekgobela's cross-examination will continue. For Newzroom Afrika on Channel 405, I'm Veronica Mahwadi in Johannesburg.
All right, let's discuss this further with my panel of guests still joining me to talk about these cases that are continuing in the country's courts. Let me bring you in here, Mnisi, when it comes to the issue of the jurisdictional factors to search the Mercedes-Benz. We know that earlier testimony suggested that it was one of the vehicles that were allegedly being looked for, so the police were looking for that particular vehicle, but also ultimately it was then found when they were arrested at that particular scene. So would the police have needed to satisfy any requirements to search a vehicle given the suspicions that a crime had just been committed?
Yeah, so Linda, what I want to mention first is the standing order that she's mentioning. I've not seen it myself, but as the court said, it's important that when she cross-examines on it, she has a document in front of her. So I think from tomorrow, we'll be able to see where she's heading with the cross-examination at that point. But if you go to Section 22 of the Criminal Procedure Act, one of the subsections do say that when there's a need to make a warrant, an arrest, a search warrant at that time, if it's in an urgent situation, there's no need for it to be there at a particular time. So I'm just trying to answer it to say, I think what the prosecution will say is at that point, there was no time to, go and get a search warrant when the crime was just committed and they need to make an arrest at that point. Whether for the trial within a trial, the processes were done properly or not, I think that will be determined during a trial when they tried and when they've made arguments, and the judge will then make an order on that. But I'm saying in terms of a search warrant, I suppose the state will say there was no time to get a search warrant at that time, and they had to make a search warrant so that at least the commission of the crime cannot go further at that point.
Yeah, and in fact, we heard the witness saying that there was no time. If they rushed to the court, then they risked having the evidence being moved or destroyed. So let me come to you then, Sibongiseni, on the aspect of the allegations of assault. I mean, we've discussed a trial within a trial extensively, and it was no surprise to me that there was an allegation of assault in, of course, this particular instance. But just remind us of, what those allegations do, if they're found to be correct, what they do to the entire process, right? Because we're determining whether or not this evidence is admissible. So if the court finds that there was indeed an assault here, what does it do? But what else does the accused need to bring in order to substantiate those claims? Possibly we've heard in this particular court of records of course, doctors. So talk to us about those requirements.
Well, Linda, we know that whether maybe we are soliciting any evidence or not soliciting any evidence, just arresting an individual, well, it is unlawful just to assault the accused person or the perpetrator, not unless maybe there is an element of force which you need to use to apprehend someone who then is resisting the arrest. But then should it be found that, this accused person were assaulted during the arrest, I think that matter, it's something else which could possibly maybe be dealt. Maybe if they just want to sue the Minister of Police. But I don't think it will then nullify the allegation that are pressed against the accused. I don't think it will have an element that because now it has been proven that you were assaulted during the arrest, then therefore you could not be linked to these crimes. Well, it is an unlawful act which could have been done by the police. Then suffice that somebody can then venture to IP it and then investigate this police and then sue the police for the unlawful, or in fact for the assault, right? But insofar as admissibility of the evidence, I don't know as to whether after the assault, then there is a statement which was solicited. As far as I know, there is no statement that was solicited. Then there is an allegation that the arrest might have been effected through using force. Well, then does it then of consequences affect the entire case, I doubt. And then maybe also to deal with the session seizure. We know that those juridical requirements is that of they has to approach the magistrates. Say, for example, they were going to approach the magistrate and then they come back, the vehicle is no longer there. Not unless if then there is absolutely no justification just to do the session seizure, but seemingly due to the circumstances, this is a motor vehicle which was moving, could possibly have moved by that time. So I think it could possibly be justified that they were supposed just to search this motor vehicle without approaching the magistrate and get the order of the section seizure in terms of section 22.
All right, let's take a quick ad break. When we come back, we'll wrap up this conversation and give you a way forward, what to look out for in the coming weeks. So stay tuned. Welcome back and thank you for choosing to stay with us. Let's continue our conversation around the case against Vusimuzi Katmatla. The case, or the court, is still hearing a trial within a trial looking into the admissibility of the evidence that was obtained during the arrest of the alleged hitman. That's Musa Kekana, and I'm still joined by my legal analyst, Mnisi as well as Mongeni Gunene. Mnisi, thank you very much for your time. You heard there before the break what Mongeni was talking about in terms of whether or not an allegation of assault is enough to, of course, get the defense an order that says essentially that evidence cannot be admitted. Talk to us about, the other factors when you look at the allegations that have been brought against this particular, police officer, given the critical role that he played during the arrest of Musa Kekana.
Yeah, I think what I've gathered I think from last week when you spoke on this particular case, is that the reason for a trial within the trial is that Musa Kekana says he was assaulted for him to make a confession as to the location of the firearms. So those are one of the reasons. And secondly, I think it's with regards to his rights or constitutional rights being explained when the search was made. So that is why they're using the hospital records, because they showed that I think he was coughing blood because he was suffocated. So it's a critical issue that the defense is raising. It's not just for the sake of it to say, let us have a trial in a trial. And it is being tested at this stage. So it's important that these things are ventilated and they are proven, they are hospital records. And it's shown that when this evidence was obtained, it was in an unconstitutional manner. Because where they're driving with a few seconds I have, they want to use section 35, subsection 5 of the Constitution, which says any evidence that has been obtained in an unconstitutional manner must not be used. I think once they use that and then they push that the trial is rendered unfair on that particular evidence, or it's not the whole charges, obviously, but it's regards to the case of Aman Swat. So it's important that the trial goes through, and I'm interested to see how far it will go as to whether the courts will agree that the manner in which the evidence was obtained was in an unconstitutional manner. That's a very critical point on this particular matter.
Yeah, and Sibongiseni, quickly as we look ahead, I mean, what can we expect, given, of course, that these are quite critical if the defense manages to get these evidence or these pieces of evidence out? It does have an impact on the Amanswart case, doesn't it?
Of course, it does have an impact because it relates to the very crucial piece of evidence being that of the firearm. And by the look of things, maybe they have a particular strong evidence because it seems like there's medical reporting so far as the accused. And then the state will have to explain why was the accused then has to be admitted to the hospital after indeed the accused was exposed to them. And he was also coughing blood in so far as what my learned friend is saying, then maybe it will be a mountain to climb as to, in fact, why then the accused was supposed to be admitted in hospital, and then the assault, if then there was any indication so far as the doctor's report indicates that there were bruises or whatever, there is some injuries, and then they were caused possibly by infection by somebody who was assaulting, then the state will have to justify themselves there. And I don't know how, then not unless if they are if the defense maybe is intending to call the doctor, or the state will call the doctor who examined the in question.
All right, thank you very much for that. So that's where we're going to leave it at with the Vusimuzi Katmatla case, which of course is continuing in the country's court. I want us to now wrap everything that, of course, we've been talking about, starting with the Senzo Meyiwa murder trial, because that too is going to, of course, resume. Let's take a look at what you've had to say in relation to what we've been discussing in relation to the alleged gunman Vusimuzi Katmatla from Sydenham in Durban. Says, is Vusimuzi's questioning of why the mastermind is not being tried an admission of guilt, or is he ill-advised by his defense lawyers? Now, do criminal proceedings allow a trial without the mastermind in the box, even though the mastermind will also be charged with the same crime later? The same crime at a later stage. So those are the questions that that particular viewer is asking there. So, gentlemen, my legal analysts, I want you to keep that in mind, because before we wrap up the show, I need you to respond to that. Now, hi, Mnisi. If a witness in the house saw intruders with a gun different from the one that killed Senzo, it is clear that the person who killed Senzo is in the house. So that's a comment there from Anonymous coming from our WhatsApp line. Let's take a look at another one, which says, according to my observation, Mnube's testimony lacks direction and clarity, mainly because his counsel doesn't take his job seriously. He's always unprepared. I was not surprised when he asked for time to prepare, even though there'd been a long recess. He is fond of taking early breaks and end-of-day adjournments. He comes across as someone who already knows that his client has a case to answer and therefore sees no need to exert himself. I'm afraid Dr. Sibanda is going to give Mnube a hard time during cross-examination. That is Sibulelo all the way from Bloemfontein. So those are the messages that are coming through. And of course, let's take a quick look at the poll results that we've running throughout the program, because we did ask you what you make, of course, of what has been happening in the court and the testimony of Mnube. And of course, 72% of you saying that testimony has absolutely no direction. So those are the views. I would have loved for our analysts to, in fact, respond to you, but we've run out of time, and the producers in my ear are already saying it's time up. Up next is Thabo Mdluli with Newsfeed PM. It's been an absolute pleasure being in your company. Bye-bye.